Hi, I'm M Zell. I'm an estate planning and business planning attorney in Virginia, Maryland, and the District of Columbia with over 25 years of experience in counseling thousands of clients. I'm talking about the basics of estate planning. And now I want to discuss ways to protect your assets from creditors. One way to protect your assets is to transfer assets to what we call a third-party irrevocable trust. You can do this either during your lifetime or at death. An irrevocable trust, by its name, means that you cannot revoke it after you set it up. It also means that no one else can revoke the trust, change it, modify it, amend it, except in certain limited circumstances. Let me give you an example. Let's say you've got $500,000 of assets that you want to transfer now for the benefit of your children. When you make that gift to the trust, the gift may have gift tax consequences. All of us are entitled to claim an exemption from the gift tax of up to $1 million during our lifetime. Now, you have to do this in a way so that it is not in fraud of existing known creditors. You can also set up a self-settled trust. Another asset protection technique is known as a beneficiary defective inheritors trust, a BDIT. In this trust, a third party, such as your mom or dad, makes a small gift, typically it has to be less than $5,000, into a trust for your benefit over which you are the trustee. You're the beneficiary of the trust, and as trustee, you're allowed to withdraw assets. In this vehicle, the BDIT, you sell your assets to the trust in exchange for a long-term promissory note. By structuring this trust properly, you not only can achieve asset protection, you can also minimize the exposure to estate tax and generation-skipping transfer tax on assets that pass to generations, 2 or more generations below yourself. Another asset protection technique that we use frequently for our clients is the use of a limited liability company. You'll transfer business and investment assets only. Personal assets that basically you're using to live on are typically not the right assets to put into this entity. You can retain control of the LLC and transfer interests to your children or trusts for the benefit of your kids during your lifetime. If there's ever a judgment that's pending against you personally, you'll probably want to resign as the manager in control of the LLC to avoid creditors from trying to pierce through the LLC to gain access to the LLC assets. In a limited liability company, creditors can only get what is called a charging order against the person who's liable to the creditor. What this means is that it allows you as a debtor to retain control over partnerships and limited liability companies and determine the timing of any distributions of cash or other assets out of the LLC. While there are some exceptions to this general rule, particularly where there are the following facts, such as a fraudulent transfer or a bankruptcy context, the charging order is the sole remedy of the creditor to get at the assets of the LLC. Creditors rarely choose to pursue charging orders. A charging order is not an effective debt collection tool. The creditor may find itself holding a charging order without any ability to determine whether its judgment will ever be paid off by a distribution from the LLC. This uncertainty for creditors forces them to settle the judgment, usually with the debtor, on terms more acceptable to the debtor, rather than pursuing the charging order remedy. So that's how you can protect your estate from creditors. These are just some of the many techniques that we use for asset protection purposes. Up next, I'm going to discuss the basics of death taxes and who pays them.